These are the 5 things you should know about powers of attorney. Hey guys, Taylor Kaspar here, owner and managing attorney at Legacy Estate Planning, where we help parents create a generational legacy for their kids so they can have the peace of mind they truly deserve. And these are the 5 things that you should know about powers of attorney. Now, before we get down into the details, I just want to make sure you know what a power of attorney document is. They're a document that allows for you to name the person that you would choose to make financial transactions for you if you couldn't make them for yourself because you're sick, you're out of town, something happened to you, but you're still alive. So what are the big 5 things you need to know about them? Number 1, power of attorney is the name of the document and not the name of the person that you choose. The name of the person that you choose is the attorney in fact. So when you see all these references in that document to my attorney, it's not me if I'm your attorney or if I should be. It's whoever you've nominated and chosen to act for you if you can't act for yourself. 2, there are more than one type of power of attorney document. So there's something called the statutory short form power of attorney document that's actually published in the Minnesota statutes on the reviser's website. And it's also published on the Attorney General's website as well. So you can download it, print it, fill it out. And there you go. You have a valid statutory short form power of attorney. But there's also another type of power of attorney called a common law power of attorney that you can add a lot more detail to and get really specific on the things that your attorney in fact should be allowed to do. Number 3, the statutory short form power of attorney is the most widely recognized power of attorney document in the state of Minnesota. That's probably because since it's published so many places, banks and financial institutions, investment companies have at least seen this document before. Plus, I think all 50 states actually publish some version of a statutory power of attorney on their state reviser's website or on their attorney general's website. So it's something that a lot of financial institutions know about. So because of the fact that it's seen and published, it's the one that you get less resistance from people from because they at least know what it is. Number 4, the common law power of attorney is probably going to offer you more flexibility and more control over whatever it is that you want your attorney in fact to do. The common law power of attorney is the one we use most often with people who have special instances, like maybe they own a business, and so we need to say some things in there about what this person would be allowed to do or disallowed to do with respect to the business. Maybe if you're getting ready to move into like nursing home care, or you need to plan for long-term care, or getting medical assistance or an elderly waiver, your power of attorney document may need to have some special language added to it to make it have the effect that you want it to have. And you can't alter a statutory short form power of attorney document, so you have to create something new that is drafted with a lot more specificity, and that's what you would get from that common law power of attorney document. And last but not least, number 5 is that no matter what your bank or your financial institutions say, there could be liability if they refuse to honor a validly executed power of attorney document. I have heard a lot of anecdotes from other people, from clients on the internet about people going in to use a power of attorney document at a large banking institution or with some of the large investment companies that are out there in the marketplace, and they're declining to use these documents and making people fill out their forms. I always want to encourage people to be proactive and to be easy to work with whenever possible. But sometimes if your attorney in fact is going to do some banking or financial transaction for you, it's because you are not able, and you maybe can't fill out additional forms, you can't do more stuff or execute more stuff, and that can create a lot of problems. So to try to maybe get in front of it or get around it, I do like to encourage clients that once they've had their power of attorney document executed, signed, notarized, all of those things, that the first thing they do is they go take it to all of their financial institutions and anybody who might want to see it and just ask, hey, here's my power of attorney document that I just had done. Is there anything supplemental that you would want me to do or fill out so that my attorney in fact won't have problems when they come in to use this document in the future. So that's it. Those are the 5 things you should know about powers of attorney documents. But just remember that the power of attorney is only one thing in an entire legacy plan. To know more things, you can pop down to the description and download our free checklist, the 10 essential things you must have, know, and do if you want to create a legacy that lasts. So you can pop down and download that below. And of course, if you found value or you want to know more about powers of attorney documents and the other things that are in a working legacy plan, make sure you subscribe to my channel, like this video, and turn on notifications so that you never miss a video update from me.